Good morning, everyone in Southeast Asia. Good afternoon and good evening to all of you dialing in from across the globe today. Hello and a very warm welcome to you all. My name is Rocky Guzman. I'm the Deputy Director of the Asian Research Institute for Environmental Law, and I'm honored to be the moderator for today's second session and the eighth session of the second ASEAN Environmental Law Conference, where we focus on climate change, climate litigation remedies, and the vital role of judiciary and judicial processes in interpreting and enforcing environmental laws, specifically on climate change. I know this is a very exciting topic for many of you here today, with so many recent developments on climate litigation globally, and particularly in the Asia and the Pacific. But we can't wait to hear more about it in this session. The backdrop for this, of course, is the Paris Agreement, which aims to limit global warming with corresponding targets. However, current international climate responses are not foreseen to reach these goals. And many are frustrated by government inaction and threatened by climate change impacts. So citizens are taking action and fighting the fight in the fighting climate justice for climate justice in the courts. Now, having these remedies is particularly pressing for the region, as most countries in Southeast Asia have low emissions but are incredibly susceptible to climate change impacts and suffer the most from it. Climate change, therefore, has a much broader meaning for the judiciaries of Southeast Asia. Now, as climate change problems are common to all, we have much to learn from each other, especially in terms of cases across jurisdictions here. Now, this panel will look at climate litigation remedies, lawsuits, legal principles, and recent developments across the region that we hope would lead the path towards more climate action. Now, before we start, I'd like to acknowledge the organizers of this event, Ariel, the Asian Development Bank, the United Nations Environment Program, and USAID. And we also express gratitude to all the organizers and the supporters of the event, 17 of them, who made this conference possible. We also thank our three esteemed panelists today for their time and expertise. Now, after the panel session, we'll have a live Q&A. But please drop those questions in the question box below in your screens. We're also live over at our Facebook page in Ariel, so you can check this out even after this session ends. All right, let's start with the panel. We're honored to have our very first panelist. You probably all know her by now, Bryony Eels. Bryony is an environmental, social, and governance lawyer and is the team leader for the Asian Development Bank's Environment and Climate Change Law Judicial Capacity Building Program. This program supports judiciaries in Asia and the Pacific to strengthen their knowledge and procedures for environment and climate change law and adjudication. Bryony was the lead editor and the lead author of Climate Change, Coming Soon to a Court Near You from ADB, which explores climate change, law, policy, and litigation in Asia and the Pacific. Bryony, we're honored to have you. Thank you for joining, and over to you, please.
Thank you so much, Rocky. Yes, so I get to talk about one of my favorite topics today, which is about climate change litigation. As Rocky mentioned, I'm with the Asian Development Bank, and we have a program where we work with judges to support them with judicial education on climate change and environmental law. Under that program, I'll just start timing myself. Under that program, we recently published, as Rocky said, a series of reports on climate law, policy, and litigation. And the title being Climate Change Coming Soon to a Court Near You. Next slide, Angelo. So we're specifically today, I'm looking at climate litigation. And in the climate litigation report, what we did was we did a review of the various types or categories of climate litigation that we have seen and the trends that we see in Asia and the Pacific, as well as around the rest of the world. And this theme of holding governments accountable for climate action is a very big trend in climate litigation. And these cases specifically tend to focus on people's rights. So they're human or fundamental rights. They apply their constitutional rights. We also see statutory and policy rights cases, which often look at permitting matters, so EIAs, environmental impact assessments, and then a new category of cases arguing around the Paris Agreement. Next slide, Angelo. drilling down into these cases, and I can't possibly hope to go through all of the cases, and I've tried to give a selection for today's discussion. But in some of the biggest cases looking at holding governments accountable, the first case is the matter of Uganda, which is a case from the Netherlands. And this case is famous for being the first instance of a court ordering a national government to reduce its emissions and ensure that those emissions targets aligned with the United Nations Framework Convention on Climate Change and the Paris Agreement. And what was central to the court's decision were notions that under the European Convention on Human Rights, the rights enshrined in that, such as the rights to life and the right to family life, created a duty imposed on the government, and it needed to do its fair share. And what do we mean by fair share? It can't possibly solve all of the climate change issues, but it can ensure that national emissions targets are on track to achieve the goals of the Paris Agreement. So to limit global warming by 2 degrees or indeed 1.5 degrees Celsius above pre-industrial levels. The second case that I wanted to talk about is the case of Advocate Padam Shrestha against the government of Nepal. And this is really the first climate change case where in Asia, where we see a court ordering a government to pass a climate change law. This again rested on constitutional rights to life. And the court agreed that climate change is an existential threat to people, and it is undermining their constitutional right to life. Now, the government had a climate change policy. So what the court said was, in order to implement this policy, the government must pass a law, and that was the basis of the decision. You see another case from Germany also using constitutional rights, ordering the government to set a carbon budget that is consistent, again, with the goals of the Paris Agreement. I also wanted to draw attention to this last case on this slide, which is a case from New South Wales, the bushfire survivors for climate action, who challenged a policy in New South Wales and said that the policy was really insufficient. It didn't really contain enough detail about how the government was going to achieve its climate change targets. And the court agreed, so it was the Land and Environment Court of New South Wales. And essentially, I mean, I'm giving a very brief overview, but the court was saying, when there is a policy, we're not going to tell you what to put in it, but the policy must have more than mere aspirational statements about climate policy. There must be something concrete for the government to implement. Next slide, Angelo. Moving to permitting and judicial review. So this is another category of cases that is really big in Asia and the Pacific. And it's often targeting environmental permitting, EIAs, and in relation to these different types of thematic areas that are listed on this slide. So energy, renewables, fossil fuels, transport sector, water and aquatic environments, and also land use and forests. Now, Asia is a big agrarian society, so land use and deforestation is quite a significant contribution to climate change. Next slide, please, Angelo. And these are two cases. One is sub judice, and it is running currently in Pakistan. But this is an example of challenging coal. So a 10-year-old, and we're seeing many cases where the youth are challenging governments, but a 10-year-old having quite a broad range of arguments, including arguments about the Paris Agreement, saying that the government has an obligation to align with the Paris Agreement and ensure that it keeps its nationally determined contributions, keep atmospheric concentrations of CO2 to 350 parts per million. Now, the petitioner argues that this is what is required to ensure a stable climate, which is her right. She also looks at the public trust doctrine and says that under that doctrine, the government has an obligation, a fiduciary duty to ensure that it retains this stable climate. The second case is a very recent case from Australia, actually, so obviously not in Asia, but it is significant because it was an example from Australia, a jurisdiction that doesn't use constitutional litigation, but looked at the law of negligence. And at the lower instance, the Federal Court of Australia said that the court had a novel duty of care to protect, care under the law of negligence to protect Australian children from personal injury flowing from the effects of climate change. Sadly, only in the last month, the matter was appealed to the full federal court and by the government. I should say the appeal was successful for the Minister for Environment, but the decision really centered around the Australian law and the test for negligence in Australia and the requirement for causation and that there be a closeness. So the court was not convinced that it could extend the law of negligence to say that there was sufficient connection between what the minister could decide and how that would impact an indeterminate class of children in Australia. So I think we will see this matter go on to appeal. And I think the reason why the court was reluctant to make this decision is it requires an extension to the law of negligence in Australia, which really probably does rightfully sit in the apex court. Next slide, please, Angela. I do apologize that I'm running through these cases so quickly. But in terms of judicial review, we've seen some fascinating cases from Pakistan and also from Papua New Guinea. This first case of DG Khan from Pakistan looks at cement companies who challenged a government regulation about protecting environmentally sensitive water aquifers and said that there could be no more cement plants built. And in looking at this decision, the Supreme Court said that it was really important to protect freshwater aquifers in Pakistan, given the known impacts and water scarcity that will be caused by climate change. But what makes this case so interesting is that the Supreme Court considered obligations that the court and government owes to the current generation of youth and future generations, and how might we be good ancestors, and that it was important to consider the impacts on them as part of environmental democracy. The second case there is a case from Papua New Guinea, which is about an EIS mining approval, and it was suspended looking at until there will be full judicial review. And what makes this case interesting is that the court looked at what meaningful consultation should look like in an EIA context. And it meant that people must be consulted in a language that's understandable and given time to understand the impacts on them. So that is fascinating in a climate change context because it's starting to look at participatory rights and what that looks like. Next slide, please, Angelo. Because ADB, we wanted to also look at cases against private parties. So obviously, currently the most number of cases look at cases against government, but now we're starting to see human rights claims, torts actions, and other actions against private entities. And that is going to be a growth area in climate litigation, even within Asia and the Pacific. Angelo, next slide. And here are just a couple of cases. The first case is the carbon majors cases. And I know that the speakers who come after me will discuss the carbon majors case. So I'll leave it for them to go through that. But one of the biggest cases is again from the Netherlands, which is a case against Royal Dutch Shell. And in this case, the court found that the company has a duty of care to reduce its greenhouse gas emissions, and that this duty stems from the Dutch Civil Code, informed by rights to life and the right to family life within the European Convention on Human Rights. The court said Shell understood the damages of fossil fuels and that it had made misleading statements, and that there was therefore an unwritten standard of care laid down in the Dutch Civil Code requiring the company to reduce its emissions. And it has to reduce emissions, its scope 1, 2, and 3 emissions. So this means not just itself, but it has to ensure that the users of its products are able to reduce emissions. Next slide, please, Angelo. I'll move on to adaptation cases because these are really important to discuss in the Asian and Pacific context, because for the most part, many Asian countries have not contributed to climate change. And these cases tend to revolve around litigation asking the government to do more around adaptation and challenging the kinds of adaptation action that are occurring. Next slide, please, Angelo. And I want to focus, many of you will have heard about the Ligari versus Pakistan case. It is such a significant case in Asian jurisprudence because it is one of the first occasions of a court ordering a government to ensure that it actually implements its climate change policy and legal framework. And the case really does focus a lot on adaptation because if you recall, it's about a farmer who came to the court and said, I don't have enough water. And so the court agreed that this was climate change was again violating the right to life and that there needed to be further action. And I'll leave it for the other speakers to talk about the fascinating range of orders that it made for implementation. Moving to the other cases that are on this slide. So the second case there is a case from India, Gaurav Kumar Bansal, in which the court ordered both the central government and state governments to start preparing action plans on climate change and for state governments to comply. So the courts are very aware that there needs to be implementable policies. I'll move to the next slide, please, Angelo, because I'm aware that I have very limited time. So these are the reports that the Asian Development Bank published in late 2020 about climate change law, policy, and litigation. I have been speaking to you about the second report on climate litigation, but there are resources in report 3 about climate change legal frameworks within Asia and the Pacific. We also talk about international legal frameworks, and we also talk about climate science. Now, we're aware that we're not climate scientists, but climate science is challenging. So it's an effort to provide resources to judges and lawyers for some of the basics and where to get information. So to sum up with my last slide, some of the takeaways are, in the 21st century, I've said this before, we have 21st century challenges. And so in any case that we're running, we really have to consider what are the climate and environmental law dimensions to the case. Climate change won't always be in that big challenge against the court saying against the national government requiring broad sweeping changes. Sometimes it's in an environmental impact assessment, or sometimes it's in a water case. So be aware, and that is what climate conscious lawyering requires. That awareness and that willingness to just be a little bit creative about the kinds of remedies that you are seeking and how you draw connections between the different issues. And to the lawyers and to the judges who are listening, skill is really needed to understand the impacts and the applicable challenges. And it is worth looking at comparative litigation across the region and around the world so that we can understand and start providing climate responsive remedies. Thank you so much for this time.
Thank you so much, Bryony, for that very comprehensive, but very quick overview of all the cases, climate litigation cases. We see that we can draw lessons despite different domestic legislation and regulations. We can actually draw legal principles. I saw a number there like public trust, intergenerational justice, and the application of other constitutional rights. That's something that we can discuss further on, and how we can draw lessons from this in the Southeast Asian context. Now, I saw that Matthew posted also the link to the climate change coming to courts near you, so you can also check that out. And again, thank you very much, Bryony. And now we proceed to the next panelist. So our next panelist, we're happy to have Dr. Lisa Benjamin. Lisa is an assistant professor at the Lewis and Clark Law School, where she teaches international climate change, environmental justice, energy resources, and administrative law. Her research investigates the intersection of corporate, energy, and environmental law with a focus on climate risk and climate justice. She is also currently a member of the Compliance Committee of the United Nations Framework Convention on Climate Change, or UNFCCC, and a member of the expert peer review group of the UN-backed Race to Zero campaign. Lisa, thanks for being here, and you have the floor, please.
Thank you so much. It's such a pleasure to be here with you. Thank you very much for the invitation. I'm going to share my slides and hopefully go. You can see them in full screen now. I want to focus a little bit more on a fewer cases, and Bryony did a great job of walking us through what's happening around the world, and I want to focus a little bit on just 4 or 5 cases. But before I do that, I want to look at loss and damage, mainly in the international arena. And the reason I want to do that is because it has a unifying theme to some of the cases that I want to examine with you today. In particular, some of the cases that are focusing on really extreme damage. And in my view, I think some of the litigation and some of these cases actually move beyond what the international treaties and the international climate system has been able to do. And I'm also going to focus on cases that look at non-state actors and corporations. So very briefly, I'm sure most of you have heard of mitigation and adaptation, and a lot of climate litigation does focus on adaptation, but some climate litigation actually tries to achieve remedies or prevent loss and damage. And loss and damage has become a really important concept for very vulnerable countries, including those in Asia and the Asia Pacific region. Loss and damage has a varying definition. It is included in the Paris Agreement, but generally the definitions broadly look at impacts that go what we call beyond adaptation. And so these are things that you really can't fix or reverse. And so even with all the mitigation that we can do now and all the adaptation efforts we can do, the idea of loss and damage is it really is irreparable damage. And so just some very brief examples of this. Loss, I'm from the Caribbean, and so loss would be something like coral reef that bleaches and dies. It cannot be repaired and it cannot be recovered. It's an irreparable loss. An example of damage is something that is actually recoverable. So this is an example of a road in the Bahamas that was a highway that was washed away from a hurricane. This is damage where you could actually repair it, but it's either so expensive for the country or there are technical constraints that it's really difficult to actually repair the damage. The concept of loss and damage is applicable under the international treaty system to developing countries or global south countries. So ideas of some of the impacts that you will have already experienced in the region, things like ocean acidification, sea level rise, these are often slowly accumulating impacts that will eventually cause irreparable loss and damage. And of course, typhoons, hurricanes, flooding, storm surges, those are typically extreme events that also are the cause of loss and damage impacts. I think one of the ways that it's been described that I find quite compelling is that loss and damage falls under impacts that are what 2 authors have called intolerable. They're intolerable risks that affect the core social and development objectives of countries. And so that will affect the health, the welfare, the safety of citizens in a country, and sustainable development objectives of a country. And so it's very much related to some of the arguments around human rights that Bryony has discussed in some of the cases that she covered. And so the idea of impacts to human rights is very closely connected to loss and damage. Under the international treaty system, under the UNFCCC and the Paris Agreement, human rights is not very well developed within the provisions. It appears in the preamble, but loss and damage is much more mature in terms of how it is dealt with in the Paris Agreement. And so during the Paris Agreement, there was a concern. There was already an existing institution for loss and damage called the Warsaw International Mechanism. That was a mechanism that was established by parties through a COP decision and the Conference of Party Annual Decisions. But it was a mechanism that was done by a COP decision, agreed by a COP decision. And so the concern of the parties was that it could be undone. So it wasn't a permanent fixed institution through the treaty structure. And in particular for small and developing states and other highly vulnerable nations, they wanted what's called a permanent anchor of the Warsaw International Mechanism to make sure that loss and damage was fully anchored within the Paris Agreement and therefore was considered separate and apart from adaptation, which has always been part of the international treaty structure. And so that was the concern. And that's why we ended up with Article 8 on loss and damage in the Paris Agreement. The Paris Agreement collectively recognizes the importance of averting, minimizing, and addressing loss and damage. And it gives examples of loss and damage from extreme weather events and from slow onset events. It also puts the onus on the CMA, which is the governing body of the Paris Agreement, to enhance and strengthen the Warsaw International Mechanism for loss and damage. And there's a lot of language around enhancing understanding, action, and support for loss and damage. And by support in the international treaty system, we mean money, and so financing for loss and damage. There was sort of the idea of facilitating finance for loss and damage. It wasn't originally tied to the Green Climate Fund under the Paris Agreement, but subsequent COP decisions have tied it to that financing mechanism. And the Paris Agreement actually includes certain areas under Article 8 for loss and damage, which countries can work on and provide financing for. And so that includes investing in early warning systems for extreme events, for example, emergency preparedness, which we all have experienced now in the Global South events where disasters and disaster preparedness is really important. Preparing for slow onset events, so basically climate migration, moving away from coastal areas, and trying to plan for irreversible and permanent loss and damage. So these are risk assessment mechanisms, risk insurance facilities so that countries can try to at least purchase insurance on the market. And there's also the concept of non-economic losses. Non-economic losses are considered by the international community to be losses like cultural losses or losses of your community, losses of ancestral graves and other sacred places. And so those ideas, it's not as fully developed as economic losses are, but it is also the idea that with climate change and with extreme events and with climate migration will become loss of cultures. And we've seen this come up a little bit in some of the litigation. And then of course, the investment in resilient communities. There were concerns by developed countries in particular around the really forceful move by vulnerable countries, in Global South countries in particular, to include loss and damage in the Paris Agreement. And in particular, this was the concern that developed countries did not want to be liable for compensation or liability for loss and damage. And it's very interesting that some of the climate litigation that we're looking at is trying to achieve some of the exclusions in the COP decision for liability, basically for climate damages that parties were not able to agree to in the Paris Agreement itself. And so accompanying the Paris Agreement is the COP decision that was agreed, and COP decisions are Conference of Party decisions. Conferences of parties are held every year in different locations around the world, and so we just had COP26 that was in Glasgow, Scotland. The COP decision that accompanies the Paris Agreement refers to the article in the Paris Agreement itself and says that the Paris Agreement Article 8 does not involve or provide a basis for any liability in compensation. And so while COP decisions do interpret the provisions of the Paris Agreement, there is a question as to the legal bindingness of a COP decision. The Paris Agreement is a treaty. It is an internationally binding treaty. And so while the provisions within the treaty have various levels of bindingness, I like to call it, depending on the language that the parties used, COP decisions are agreed every year. They do provide interpretations of the Paris Agreement, but they're not a treaty. And so while they have some persuasive impact, they're not legally binding treaties. And I say this because there has been so much frustration, particularly by developing countries, as to the lack of movement now by the parties on loss and damage, that small and developing states in particular are considering bringing a motion to the UN General Assembly to basically ask for an advisory opinion from the International Court of Justice, particularly around climate liability. And so if they are successful in getting an advisory opinion, the ICJ will then start looking and digging into Article 8 of the Paris Agreement and also the accompanying COP decision. And so there's actually the potential for litigation around the international treaty system, particularly by very vulnerable countries that are not being able to secure the financing that they need to be able to invest in a lot of these policies that courts around the world are basically saying that countries should have, including adaptation policies. So it's a really interesting space to watch, and we'll see what happens. So moving on to some of the actual litigation that's happening, I want to focus on a couple of cases that involve non-state actors and in particular involve instances of loss and damage. And this is one of them, the case brought by Mr. Luia against a company, RWE, which is a German utility company. This is one of the first cases, and there have been successive decisions along the way, but we don't have a final decision on liability yet. But it was a really innovative strategy brought by a German lawyer on behalf of Mr. Luia, who's there in the picture. Mr. Luia is a farmer in Peru. And his concern was that the German utility company, the emissions from that company, were causing a certain percentage of global emissions. And so those emissions were likely to melt a glacier around his village, inundate the village, and cause irreparable loss and damage to his village. And so he asked for the same amount of money from RWE, a private company, as mirrored their contributions to global emissions. And so we can see the mixture of both the emissions globally that a company emits being corresponded to the amount of money that's being asked by a vulnerable community to help them address or at least prevent impacts from loss and damage. And so this is a picture of his village, and you can see that there's a glacial glacier behind it and a lake, and the concern is that the glacier will melt and the levels of the lake will rise and basically overtop the natural barriers around it and flood the village. So there was one decision that actually said that in principle, at least, RWE, the company, could be responsible for this compensation, and now they're going through quite a lengthy period of gathering evidence. So it was a really interesting decision, at least in principle, around climate liability from a company. The second case, it's really an investigation by the Philippines Human Rights Commission that I want to talk about, was also really groundbreaking. So these are some of the first decisions that sued non-state actors, and this was an investigation. And the reason I find it so innovative is that it was the Human Rights Commission in a developing country that investigated 47 what we call carbon major companies, so companies that are very fossil fuel intensive. And they were just investigating the potential liability of these companies for basically instances of loss and damage, because this came on the back of Typhoon Haiyan in the Philippines, which killed several thousand people. And so they held hearings in the Philippines, in New York, when I was able to attend the hearings in New York, and in London. And New York and London are strategic because those are where the parent companies of most of these global multinational companies reside. And so it was a really interesting set of hearings. They were able to reach out to Filipino communities within London and New York to be able to talk about their experiences, for example, from Hurricane Sandy in New York. So creating a community of basically the vulnerable who were able to share their stories and highlight their stories through this commission hearing. And then I won't spend too much time on this because I think Mamita is going to cover this case, but the Ligari case really is famous around international climate change circles. And in particular, I want to try to pick out some of some enduring and universal principles that I think we can learn from all of these cases, even though they appear in different jurisdictions around the world. And in particular, some of the really strong statements by the judge in this case about climate change and the importance of climate change, and focusing specifically on the impacts of climate change on human rights. There were some really innovative orders that came out of these series of decisions, and in particular, the need to protect the most vulnerable within Pakistan against the impacts of climate change. And so this was a really interesting case for me, and from a developing country, where I find that a lot of issues are around implementation of laws. And so this really was a series of decisions that really require the government to strengthen and develop adaptation plans, and to actually establish a commission and a structure to actually implement those plans. And so it's a very innovative decision. I then want to end with two cases from developed countries. And again, they are basically against corporations. Bryony touched on this a little bit, and I want to try to highlight from the Shell case against an NGO which brought it against Royal Dutch Shell, some universal principles that we can possibly apply in other jurisdictions. And so while this was very much based on the Dutch Civil Code and followed on from the Urgenda decision, it actually relied quite heavily on a number of IPCC reports. It also relied on Richard Heaty's study, which was relied on with the Luia case as well against RWE, that Royal Dutch Shell, the corporate entity, and that includes all of its subsidiaries, is responsible for about 1.8% of all global CO2 emissions. In fact, multiples more than the 0.5% that the Dutch state itself is responsible for. And so because of the disparity in terms of contributions to global emissions, the court was able to find that Royal Dutch Shell knew about the risks of climate change and did nothing. They also, as a company, the court found, knew how much the threat of their emissions would impact the human rights of Dutch citizens. This is a really innovative decision because it doesn't just apply to the parent company of Royal Dutch Shell, which is based in the Netherlands. In fact, the court said this applies to you as a parent company and to all of your subsidiaries all over the world, and that will include subsidiaries in global south countries of the multinational. In addition, another really innovative part of this case was that the court said this applies not only to your scope 1 and 2 emissions, which are the emissions that come from the facilities themselves of the company, and scope 2 is in relation to their supply chains, but the court said this applies to scope 3 emissions. And so those are the emissions from the use basically of oil and gas from consumers around the world. I was even, although I studied corporate litigation against corporates, I was even surprised by the robustness of this decision. And so while the court said that the company is only responsible for best efforts to reduce their emissions, the scope of the best efforts and what it applies to is really very broad and very large. And so that will apply to suppliers and extraction all over the world, including global south countries. In addition, many of these cases rely heavily on the IPCC report at the time, which was one of the most recent ones, the 1.5 report. Since then, we've had assessment report 6 start to come out from the IPCC, the Intergovernmental Panel on Climate Change. And again, the court said that the IPCC reports have been so clear about what tremendous risks that climate change are posing to human rights. And because Royal Dutch Shell is a multinational company, it should follow global reduction pathways, and therefore it should be following the IPCC directions of reducing emissions by 45% by 2030 and net zero by 2050. And so therefore, Royal Dutch Shell had to take those kinds of actions to reduce their emissions. And then the last 2 slides, I also want to highlight from the Dutch decision that some of the business guidelines that the court also relied on are UN guiding principles on business and human rights and the OECD guidelines for multinational enterprises. Most of us who have looked at these thought that these were very soft, non-binding provisions, and yet the court took a very robust interpretation of these, and these are universal principles, and all multinationals have basically volunteered to comply with them. And so they could therefore, in theory, apply across many jurisdictions and many companies that subscribe to these. And then my final slide is in relation to the US. And so while the US is not seen to be very forward and progressive in terms of climate litigation, there is a lot of activity going on in the United States. And in particular, there have been a suite of cases against carbon major companies brought by states around the United States. And so one of the more recent decisions, it's been a lot of back and forth about jurisdictions and where in which level the case should be heard. Should it be heard in state courts or should they be heard in federal courts? One of the latest pronouncements we've had from the court in Hawaii actually was that the motion by the carbon major companies to dismiss the claim and try to move it to the federal level, which would be very bad for the states, is that it was denied. And one of the statements that was made in this case was that, well, fine, climate change is unprecedented. And this speaks, I think, to a lot of some of the issues facing the judiciary when they're faced with a climate change case. But the court said it's still a tort case and it's based on state laws and causes of action. And so a lot of states will have failure to warn legislation. You didn't warn us of the risks when we were purchasing these products. And so this is one of the first decisions. We don't have a substantive decision yet, but there are implications for these carbon major companies in whichever jurisdiction they are sued, because they will then have to apply that judgment across potentially a number of their subsidiaries, which could also be in the global south. So that's the end of my presentation. Again, I want to thank you so much for the invitation to be here.
Thank you very much, Lisa, for those very interesting points about loss and damage. I think that term has been thrown out like a lot of times in climate conversations, and not a lot of people have actually defined this. And thank you for giving us that clear definition. And it also goes back to an earlier point that particularly in Southeast Asia, adaptation and response is so much more important relative to like other developed countries where mitigation is much more of like the issue there, right? And also a point that we can discuss later on the Q&A is that there are a lot of like developments, not just holding governments accountable as such as like traditional causes of action, but also going towards like more accountability of like corporations and like other actors. So we can talk about very interesting points. So just a reminder to all of the participants, if you have any questions, just please put them in the Q&A box below. We'll have much time for discussion later on for this very interesting topic. And I'm really looking forward to that. But for now, we proceed to our last panelist. Our last panelist is Momita Das Gupta. Hi, Momita. Momita is a lawyer affiliated with the Supreme Court of Bangladesh and a research fellow for the Center of Climate Justice, Bangladesh. She works on legal and policy issues related to climate change, environmental and natural resource management. Momita is a legal practitioner and earlier worked with the Bangladesh Legal Aid and Services Trust, or BLAST, as a community justice and research fellow. Let's all please welcome Momita. Momita, over to you. Momita? Just checking if Momita is here.
She's still here. We have some connection issues.
All right. Welcome back, Momita. Please go ahead.
Thank you. Is the slide showing here?
Not yet.
Not yet.
Attorney Mumita, I can share the slides from my end.
Yes, that would be great. Please.
Okay.
Okay. All right, perfect. We can see the slides. You can go ahead, Bomita. Yes.
Hello, am I audible?
Yes, you are audible. Please go ahead.
Thank you. Hi everyone, I am Momita from Bangladesh and I am going to speak on climate change and the litigations in Asia. My co-speaker is now in Germany and attending the EXCOM meeting of Warsaw International Mechanism, so he is not being able to join us. These are the contents of our discussion, and we are going to discuss the backgrounds of Bangladesh and Asia. About Bangladesh, the Constitution of the People's Republic of Bangladesh has not provided any specific provision for public interest litigation or environmental litigation at the very beginning. Article 102 has empowered the High Court Division to issue certain orders and directions if satisfied that no other equally efficacious remedy is provided by law and on the application of any person aggrieved. Also, the Constitution has guaranteed for right to life. By utilizing these provisions, Dr. Muhyiddin Farooq, the founder of Bangladesh Environmental Lawyers Association, BELA, has started a journey of both public interest litigation and public interest environmental litigations in Bangladesh in late 1990s. He filed several writ petitions against the government, and the Apex Court of Bangladesh had grabbed these opportunities for practicing judicial activism. At first, the challenge was that the flood action plan, the activities of flood action plan was challenged as being likely to adversely affect both natural resources and human lives. So the court found that the Constitution does not contain empty phrases. Constitutional functionaries and institutions exercise not their own but the powers of the people on terms of the expression of the Constitution, and person aggrieved includes one whose heart bleeds for his less fortunate fellow beings for a wrong done by the government and or a local authority. So part 2 of the Constitution is being used as the interpretative tool of the Constitution, and FAP would adversely affect more than 1 million human lives and natural resources. So it was found as an anti-people plan. Later, in a later occasion, the court found that the Article 31 and 32 guaranteed right to life. This expression life does not mean merely an elementary life or subhuman life, but connotes the life of the greatest creation of the Lord, right to a decent and healthy way of life in a hygienic condition. It also means a qualitative life free from environmental hazards. So these decisions paved the way for public interest litigations in Bangladesh and public interest environmental litigations in Bangladesh. And in later occasions, these responsibilities was conferred on the local authorities also in Rajasthani Unnayan Kortripokho, Capital Development Authority and others case, and the case against Dhaka City Corporation. So, and it was in the late 1990s and early 200s, and this trend is being continued since more than 25 years in Bangladesh. And the recent trend is that in Turag River case, it was filed by Human Rights and Peace for Bangladesh, and in this case, the court has applied the public trust doctrine declared that the river Turag as a living and legal entity. River Protection Commission is declared as the person in loco parentis as all the river, including including Turag. Precautionary principle and polluter principles are declared to be a part of the law of the land, given some of the other direction to comply with as continuing mandamus. So these directions will be reviewed, and this is the continuing mandamus. And in a recent case, Bella, it is still pending, just filed by this year. An interim order was passed on 15 February 2022. It required to show cause as to why failure to control air pollution and protection of public health is not illegal out of legal authority and against the public interest, and as to why no direction will be passed for developing a time-framed action plan to control air pollution and to improve the air quality. So it was the continuation of the 102 and right to life provisions, and later in 2011 Constitution of Bangladesh got amended and a new article 18A was inserted. This article provided for protection and improvement of environment and biodiversity and the interests of the present as well as the future citizens of the country. This is inserted in the fundamental principles of state policy part, not in the fundamental rights parts. But though it is not judicially enforceable, it is allowed to be used as the interpretative guide of the Constitution. So this has a great implication on the legal affairs. And after this inclusion, this provision is being applied by the court, applied by the Apex Court of Bangladesh. In Government versus Mohammad Mushfaqur Rahman, land was leased, allotted lease to Mohammad Mushfaqur Rahman. It was this land was situated at Cox's Bazar at an environmental critical area, and later the government has cancelled the lease. So Mohammad Mushfaqur Rahman challenged the cancellation and we won in the High Court division. So the government has filed the appeal and in the appellate division. And the appellate division found that the leaseholder can get compensation for the lease cancellation, but the lease cancellation order will be upheld because this area is environmentally critical. And in Rana Surang versus Government of Bangladesh, it was about cutting trees in the tea state of Kulaura, Molavi Bajar. In Jhimai Tea Punji, Jhimai Tea State, Rana Surang was the headman of headman of the community, and he challenged the decision of cutting trees. So High Court division upheld the decision of cutting trees, but the appellate division found that it is not right to cut down the trees and ordered to plant 2 trees prior to cutting 1 tree and nourish that for 3 years to grow it enough, and then it can be considered to cut the older trees. And these decisions has referred to Article 18A only, and these decisions has paved the way for climate litigations in later occasions, though these are not directly climate litigations, these are environmental litigations, but this is this opened wide avenue for successful climate litigation in future. This is the scenario for Bangladesh, and if we see the scenario for Asia, yes, we have found 7 countries of Asia who have climate litigations, and there are 20 climate litigations enlisted in the Sabin Law Center website. And we have studied these litigations, found that the plaintiffs or petitioners are mainly individuals, group of individuals, NGOs, CSOs, or combination of combination of individuals and NGOs and CSOs. And defendants are mainly the government, and only 3 litigations are found in Japan that are filed against corporations. So one exception in Pakistan, DG Khan Cement Company versus Government of Punjab. In this occasion, a cement company of Pakistan challenged lawfulness of a provincial decision for barring establishment or expanded climate cement plants in environmentally fragile areas. The court has upheld the decision of the provincial government and dismissed the case. So in these occasions, the judicial forums are found, litigations are being filed at Supreme Courts, High Courts. In case of Japan, district courts are also allowing to file these petitions, and in some of the cases there are special courts who can allow these petitions, or who can take these petitions for considerations. And for jurisdictions, all these cases are within national jurisdictions, no disputes in regional or international forums. Only one occasion in Japan, exception, it is exception that transboundary considerations was taken into consideration. Individuals filed a complaint against corporations by challenging funding in Vietnam by Japanese bank. By considering the OECD guidelines, the national contact point for OECD guidelines has dismissed the matter on procedural issues. Procedural issues means they said that no agreement of the parties to solve this issue was there. So this procedure was dismissed, and it was not dismissed on merit. So the issues in dispute are challenging any action, inaction, and inadequacy or inadequacy of any action amounting to create or increase climate hazards as alleged. Principles laws are being based on mainly international obligations like Paris Agreement and human rights, constitutions of respective countries, specific parliamentary legislations, national policies, plans, and government orders, and combination of more than one of them. So the courts are providing remedies with relevant directions, order to establish necessary expert committees, combine these remedies together. Sometimes the litigations got settled due to compliance on behalf of the government. Among 2 writ of mandamus, 1 has resulted into supporting parliamentary litigations, 5 are dismissed, and 7 are still pending. So there are some case studies from different countries of Asia. In India, National Green Tribunal has undertaken a suo motu proceeding, and it's issued restrictions to curb black carbon emission, ended with directions to comply with, and establishment of an expert committee. In Japan, the notice was given for subsequent operation of new against subsequent operation of new coal-fired power plants, and this was dismissed at Osaka District Court. The appeal is still pending. In Nepal, Padam Bahadur Shrestha case, it was filed by seeking an order to compel government to enact adequate climate change laws, and Supreme Court issued writ of mandamus. It was complied by the government later on. So In Pakistan, Ligari case is already discussed by my previous discussions. In Philippines, together NGO, CSOs and individuals brought proceeding in front of Commission of the Human Rights, investigating into allegation that largest emitters have violated human rights of Filipinos and changed the climate change, and it is giving rise to ocean acidification. On December 9, 2019, the Commission announced its finding that major fossil fuel companies held liable for climate change impacts. Investigation is completed and decision is still pending. So we see that courts are supporting in their decisions and observations. Governments are complying. More research and careful studies are required to take cautious steps for future successful climate litigations and for better remedies. So these are our findings. Thank you so much. Thank you.
Thank you very much, Momita, for that insightful discussion on climate litigation in Bangladesh, and also for covering litigation across the Asia-Pacific region. So many initiatives and cases ongoing right now. And I particularly love your point about using the right to life in the Constitution in filing these cases. That's perhaps something that we can discuss later in the discussion, and how we can apply these constitutional rights in all these climate change litigation cases, right? But thank you very much again, Momita. And at this point, I'd like to thank all the panelists for their fantastic presentations. And we are now proceeding to the exciting part of this session, which is the open forum. And we'll be opening the floor to all the questions from the audience. And thank you, Bryony, Lisa, and Momita. We have a few questions here. The first question, very interesting, is all of you have discussed perspectives and cases from developed countries and developing countries. I'd just like to get your thoughts and comments on what you think is the difference, and what are the differences in perspectives and the approach of litigation between the developed world and the developing countries. So maybe I'll start with Bryony.
Thank you, Rocky, and thank you, Joshua, for that great question. I think Asian jurisdictions have done, they've innovated in terms of standing. So they have liberalized their rules of standing. So they've made it easier for younger generations to sue and to bring these big climate lawsuits. And a lot of that rests on the fact that they have liberalized standing in respect of constitutional rights claims. And that has allowed them to accept these claims. I think that the case of Opposer versus Factorin is, it was a case that was clearly ahead of its time. And if you remember, it really came around, some big conferences which were looking at the rights of intergenerational equity. And so I think that case is really a watermark case, and I'm not aware of other cases in Asia and globally. Maybe, Lisa, you've got a different perspective, that allowed unborn citizens to bring a case. Another interesting development in terms of this concept of intergenerational equity was explored in the case that I touched on, which was the matter of DG Khan, which is in a sense almost a routine matter where a cement company was just challenging a decision to have regulations that prevented it from expanding its cement plant. And, it brought a constitutional claim itself to say, well, we have a constitutional right to be in trade and business. And the court, after looking at all of the obligations that the regulatory agency need to look at and finding it was sound, then spent time looking at the obligations of governments and courts in respect of youth and future generations. And it was very aware in writing that decision that we really need to, part of environmental democracy is being good ancestors and allowing and taking into consideration the needs of future generations in making these decisions. And that was additional consideration that the court brought into that case. So I think that Asian jurisdictions have innovated quite effectively on this issue of intergenerational equity.
Right, thanks. Intergenerational responsibility, 1990, all these are from developing countries. So these are being adopted even across different jurisdictions, even developed ones, right? Any thoughts, Lisa?
I agree with that, Brownie. I was in 2018 with a colleague thinking of writing an article about climate litigation in the Global South. And at that point, we were like, is there enough to write about? And that was only 3 or 4 years ago. And we did write it. And at that time, another article came out, and it was really the first couple of articles looking at climate litigation in the Global South. And now that, of course, I look back on it and all of the cases that Momita has talked about, there's such a rich jurisprudence in the Global South about environmental rights and protection of intergenerational equity. And so there was a really rich foundation, I think, there that was then just translated into the climate context with some cases that started coming out in the Global South. And I think that in terms of the next sort of suite of that, we see that kind of innovation happening around rights of nature in the Global South. We see it in Bangladesh, as Momita has talked about. We see it in Colombia in relation to deforestation and claims by youth to stop deforestation, and so establishing rights around natural resources. So I think that the Global South countries have been really innovative and are really providing lessons basically to the Global North about what can be done through jurisprudence on climate litigation. I think when you're speaking about the Global North, you have to really separate the US out from the rest of the Global North. And so countries like the EU have been quite innovative because they have structured conventions on human rights, where then you don't have that kind of background and structure in the United States. And so that's why there hasn't been as much movement in the US around it. And also you have this sort of federal state dichotomy in the US, where at the federal level, legislation is seen to displace tort actions around climate change. Canada is also very interesting. It's really at the nascent stages of climate litigation. So we are only starting to see 3 or 4 cases coming out of Canada and being started to be litigated by youth and by Indigenous communities. And so you can see it's the highly vulnerable communities in these countries that are really pushing this forward.
Great, thanks. Much to be learned from the Global South in terms of innovative legal approaches. From Bangladesh, perhaps, Momita, do you have any thoughts?
From Bangladesh, we are seeing public interest environmental litigation since over 25 years, but there is no climate litigations yet. But insertion of new article in Constitution has started the chances and opened the avenues for successful climate litigations, and that is supporting for present as well as future generations for natural resources that was absent in the previous document of Constitution, because the Constitution was drafted in 1972, and at that time environmental matters was not so much concerned in national level. But in later occasion, when it was developed as a greater concern, and Bangladesh was and is being heavily impacted by climate change effects, and that's why the government has considered these matters and included these rights in the Constitution. So that is hope for future, and that's the present situation.
Right. Thank you, Momita. And Brioni, would you like to add?
Yeah, I wanted to add to that point. And I think the definition of climate litigation is something that is hotly debated in academic and legal communities about what is a climate change case. And so, and you know, I agree with Lisa. When ADB started our report series on climate litigation back in 2017, we were also thinking, oh my goodness, what will we write about? But for the purposes of our report, we took a much broader perspective about what is climate litigation, because our focus is not academic, it's about connecting the dots between what are the causes and impacts of climate change and what cases have co-benefits or flow-on impacts for climate action. So, a case doesn't necessarily have to plead or specifically use that label of climate action to be relevant for climate change. And so in Bangladesh, we covered cases looking at the protection of floodplains in Dhaka. Now, Dhaka is one of the world's most vulnerable cities to sea level rise and to flooding as a consequence of climate change. And so any cases that are in protecting natural flood zones are going to be relevant for climate change, even if those cases are not raising the issue of climate change. And I think that's what I was getting at when I was talking about climate consciousness, is every jurisdiction needs to understand what are the impacts for you locally. And you don't always have to use the label of climate change to make an impact and for a case to be relevant to climate change. So when we say there are a few climate change cases, maybe that's the case for a very narrow definition. But if we start to connect the dots and think broader, then we see that actually there's a lot of environmental litigation that's actually slipping into the courts as climate litigation just without the label and unawares.
Great point. Yes, we only on the definition itself covers so much more than just strictly climate litigation. And there's another interesting question here. I think you've touched upon this, Lisa and Bayoni, on your presentations on going towards cases or accountability against companies. So a lot of emissions come from carbon majors, and top contributing sources are from developed countries. What is the status, and what do you think is the way forward in Southeast Asia in particular on these cases against corporations and other actors? We can also look at in terms of restitution, remediation, all these remedies. How can we exact accountability?
I can talk a little bit about that. Again, it's only been a recent, in the past couple of years, that litigation has been taken against non-state actors. In the case that I talked about with Mr. Luia against RWE, that's a transnational action by emissions in a company based in Germany and the impacts being felt in Peru. So it's a really complicated set of causation arguments that they're trying to build. And the fact that in principle, at least, the German court was willing to accept those causation arguments was really surprising for a lot of us that have been watching this space. And so, of course, you have to go after the companies that historically have contributed a significant proportion to global emissions, and those are the big ones like Royal Dutch Shell, and there's a set of carbon major companies that are the sort of top 50 emitters around the world, and that has actually been tracked in a couple of scientific papers, and in fact their contributions to sea level rise and to actual global temperature increases have also been tracked through attribution studies. And so there is evidence there that's been cited in a number of cases. The case against Royal Dutch Shell in the Netherlands is one of the most recent and innovative decisions. It's being appealed, of course, and RDS is moving its headquarters now out of the Netherlands. So, there are always those strategies that companies can use. But I think another area of litigation, even if it's not directly in terms of requiring mitigation, but also and compensation, which is what is being requested in the cases in the United States. These states that are vulnerable, like coastal states like Hawaii, are asking for money for adaptation, or at least that the companies try to reduce their emissions. I don't know how successful these cases will be in the United States. Another series of cases that are happening are cases around greenwashing. And so, as we have called it, a couple of authors and I wrote a report on climate washing. So basically you have a lot of net zero commitments made by companies that they're trying to be net zero, but not a lot of transition plans around that. And they could actually be facing legal liability for those kinds of statements when they're not actually doing anything about it. And those could be through advertising standards, where you actually have much more specific requirements about misstatements and misselling of products. than you would have trying to make that causation argument against companies. So there's a whole potential range of litigation. There's also securities litigation that can be brought against companies for not informing investors about the risks of climate change when they were selling securities to the market. And so there's a whole potential set of pieces of litigation. They're not as mature as the other actions against state governments yet, but I think that it's going to be a growth area.
Right. This is going to be in a very exciting space, especially with all these cases with the Shell cases. And Brian, perhaps from, yep, sure.
There's a recent case in Australia, indeed, and against Santos, which is one of Australia's largest gas producing companies. And what's interesting about that case is that Santos is actually part of the Climate 100 Plus initiative. So it's made very strong statements around heading towards net zero. But what happened was the Environmental Defenders Office in Australia reviewed their policies and looked at the sums and the maths, and that's what's starting to happen. Markets are really starting to look at what statements are being made and saying, you know, you're saying you're reducing your emissions, but your policies simply do not have you on track for that. So that will be a growth area. And also, as Lisa touched on, this concept of directors' duties and their obligations of disclosure. So ADB did a webinar late last year looking at private sector director duties of disclosure. So I'll get my colleagues to put in the chat a link to that if anyone is interested in watching that. And the other area that I would say is really compliance. And that's really going to be an issue around adaptation. So we're going to see more litigation around companies that that as a result of some climactic environmental event have suffer damages, and that those damages have flow-on effects for surrounding communities. So cases like that would see both damages and probably torts from surrounding communities, but also compliance and regulatory fines, I suppose, imposed on the company.
Right. Like all these important points, like the duty of care and like compliance, of course. And I think you've mentioned in your presentations that also due diligence, environmental due diligence, which is like also guided by some guidelines, such as the OECD guidelines that you've mentioned. Very important points on holding corporations accountable on their climate change impacts. Now, I'd like to go to a point which Momita stressed on her presentation in Bangladesh, and it's like you used the right to life in these climate litigation cases, and I think you've also touched upon this, Brian and Lisa. In some of the other cases, you've used other constitutional rights, like rights to environment and right to health. All these, like, how can you give us your comments on how you use this like horizontal application of constitutional rights in terms of climate litigation? Perhaps would like to go first.
Constitutional rights. Okay, in respect of Bangladesh Constitution, there are several parts. So in the second part, Bangladesh Constitution covers fundamental principles of state policy. Those are not directly applicable by the court, but they're enforceable by the court, but those are being used as the interpretative tools by the courts for the constitutional interpretations. And the third part is fundamental rights, and that is directly enforceable by the court. And so if anyone violates any fundamental rights, that the aggrieved party can go to the court. So environmental right was not included in the primary occasion, as I mentioned earlier. So it is included in 2011, but even before such inclusion, fundamental rights, right to life, was being interpreted in the terms of environmental rights, in terms of right to health. And so after such inclusion, I think it's a great possibility for future that it will be more elaborately implemented in the national context. And I have yes, I have got some questions in the chat box, and that is a bit relevant. Shandi has asked about the definition of climate change and climate litigation and environmental litigation. I think the panelists will be more experienced about this, but I think environmental litigations cover any environmental matters, and climate change litigations are more focused on climate change matters. Like if we discuss about water pollution, river pollution, it is within the periphery of environmental matters. But when we see the climate change matters, it is related with GHG emissions that is causing climate change, that's causing climate change and having climate change impacts. So it is the narrower sense, and if we discuss in broader sense, all the matters having impacts on climate change can be termed as climate change matters, and all the litigations related with those can be termed as climate litigations. So there are many interpretations about this. So which interpretations will be accepted? That will be that is a question. And another question from
Bonita. Maybe we can continue with the horizontal application. I think Bryony and Lisa have not commented on that. On the constitutional rights first, before we proceed to other questions.
Lisa, please.
So human rights has been a really vibrant area for hooks for climate litigation, and the reasons why governments should take action and even corporations should take action. I guess I had a little bit, one of my concerns about this is that it's usually a vertical relationship by citizens in the country where you have a human rights violation against suing the government of that country for ensuring that human rights are respected. The one sort of exception to that is the Royal Dutch Shell case that we talked about, and that is Royal Dutch Shell in the Netherlands being sued successfully to reduce emissions or make best efforts to reduce emissions because the actions of that company were violating the human rights of Dutch citizens. But you usually have a pretty vertical relationship between the citizens and the government. I have some issue with that being from a developing country, because that means that developing country governments are then responsible for ensuring the human rights of their citizens due to climate emissions made by other larger countries and other companies. And so that really does put the onus on developing countries and governments of developing countries to basically pay for the adaptation to ensure the human rights of their own citizens. And that is not entirely equitable, considering that many developing countries were not responsible for a large number of the historic emissions. And that really goes back to some of the statements I made about the Paris Agreement and the fact that under the Paris Agreement, human rights is purposefully underdeveloped. The language around human rights is a preambular reference in the Paris Agreement only, and that's because a number of countries, including some global South countries, did not want human rights and obligations around human rights to be enshrined in the Paris Agreement. And so trying to make those horizontal claims about violations of human rights of citizens in one country against governments in another country is extremely difficult, and it hasn't, to my knowledge, happened yet. I think the Philippines Human Rights Commission investigation is one of the closest that we got in terms of carbon majors situated all around the world, including in the Philippines, but all around the world, and their emissions affecting the human rights of citizens in the Philippines. And so it's a very difficult argument to make both under the Paris Agreement. There's basically very little chance that there's zero chance basically that the Compliance Committee under the Paris Agreement is going to consider any kinds of claims like that. And I think just through human rights litigation, it's going to be difficult. I will make one note, though, that I mentioned at the very beginning of my presentation about the request for an advisory opinion from the International Court of Justice by small island developing states. There's also been a really, really robust set of reports coming out of the UN Human Rights Commission around climate change and the impacts of climate change on human rights, and in particular, the rights of very vulnerable people around the world and connected with poverty and extreme poverty. So there have been some really robust decisions coming out of that, and the UN General Assembly, I think, just recognized a right to a healthy environment. And so there's been some movements on it, but in terms of actual litigation and successful litigation, we're still waiting for that kind of case to be successful.
A lot of challenges in framing as a human rights issue, but there are recent developments that point to like better legal principles that could be applied. Bryony, would you like to add to that?
Yeah, I mean, I think what both Mamita and Lisa has said a really, it's hard to add to that. But what I would say in terms of human rights, what we found in our report series, we tend to talk more about constitutional rights. So it's really useful to remember that within Asia and the Pacific, we see very young constitutions. And by young, I mean most constitutions post-date the Universal Declaration of Rights, civil and political rights. So these social and civil and political rights are often enshrined within the constitutions of the countries. So rather than framing it as a human rights-based case, what we're seeing are these constitutional-based cases which have a lot of benefits because they enable litigants to go straight to the apex court, which usually has primary jurisdiction. So it kind of leapfrogs that whole process of fighting it out through, all of the different layers of courts. And what we've seen is that the courts have, particularly in the South Asian jurisdictions, but also, in some Southeast Asian jurisdictions like the Philippines and Indonesia, a broadening of the interpretation of what those rights mean. And that is to say that you cannot have life if a world can't sustain it. And therefore, of course, the right to life includes these environmental rights. And so that's how we have seen the broadening of rights within different countries. So it's not, I agree with Lisa in what she's saying about these being vertical rights and difficult to apply in different jurisdictions. But I do want to just pick up, because I know we're running out of time, on the innovation in the Ligari case, because we've all touched on it, and what these constitutional remedies allow. And that's why we're seeing innovations in South Asia, because the constitutions of these countries give courts very broad powers where there is a violation of a constitutional right. And that was the hook that the court used in the Ligari case to justify creating a climate change commission. And using a writ of continuing mandamus to require this commission to come back and report to the court continuously on the government's progress in implementing its climate change policy obligations. And it only closed the matter when 66% of the priority matters under the climate change framework had been achieved. So whilst it's a vertical application of rights, and whilst it is requiring courts to direct their national governments to take action, the use of the constitutional rights really does give the courts quite broad powers to innovate and to bring about real change within their nation, and to have broad orders, whether that's against a private actor or against a government. So that, I think that's something that's really interesting to note about a feature of Asian litigation.
Right, very interesting. And also because these are mostly enshrined in the Bill of Rights, so it makes them self-executory, right? So it'll be easier to have a cause of action based on these constitutional rights of the citizens. Very interesting. And just maybe one last question before we close, because this is a session on climate litigation remedies. You've mentioned some of the innovative approaches from Southeast Asia, from South Asia, and also other jurisdictions as well. What would you say, or what would you like share? What are the remedies such as the writs and all these actions that could be adopted by across jurisdictions across Southeast Asia? Did you have any recommendations from your from your research, perhaps?
Did you want?
Sure, Brian, you can start.
I don't want to hog the floor. I'm happy for Lisa.
Yep, anyone can share. Maybe Lisa first, and then Momita, and yeah.
I think just to pick up on the comments that Brownie made about the Ligari case, we've seen this also, these continuing writs of mandamus, particularly for developing countries where implementation of laws can be a struggle because of competing priorities around poverty eradication and other pressing issues facing governments. We also saw it in the Colombia case where youth sued in relation to deforestation rates in Colombia, which is actually the main source of emissions. It's actually not from actual emissions from factories, it's actually cutting down trees. And so again, they had a continuing order to ensure that the governments basically kept it on the agenda and had a plan to deal with it. And so I think that those kinds of remedies were really making it front and center as a priority for governments. I would say historically developing countries have not focused on environmental issues so much as a priority, but I think that's really changed as particularly not only have the courts been really robust in providing a lot of jurisprudence around environmental rights, but I think for developing countries in Asia and the Pacific, climate change is now becoming such an existential threat for such a large percentage of the population that it's really helpful for courts to be able to focus the mind of governments in terms of developing a plan, but not just writing a plan and not implementing it, but actually implementing the plan and continuing to hold governments' feet to the fire to continue to implement it through successive governments. I also think that some of the actions against companies could be really interesting in developing countries in particular. So we've had this investigation by the Philippines Human Rights Commission. A number of developing countries have human rights commissions and could also do these investigations. And so it could be a mechanism to at least try to put pressure at the international level to develop some kind of contribution through some kind of tax in relation to non-state actors to contribute to the Green Climate Fund or to financial mechanisms to be able to fund the government's efforts around adaptation plans and implementing adaptation for vulnerable communities.
Right. Yeah, very innovative approaches, the writs and all these other options like human rights and looking at the taxes. Maybe Momita, from your experience also.
Yes. As you see the previous records, there are no transboundary litigations in context of Asia. Just one, we found that Japan that was dismissed for procedural matters, but unlike other jurisdictions in Asia region, there is no judicial body that can entertain the disputes between the nations. Like EU has some setup like that. So there are such litigations in International Court of Justice and International Court of Justice, ICC, and Permanent Court of Arbitration. There are some litigations, but those are mainly between European countries or African countries, not between Asian countries. And within Asia, there are two regional bodies, SAARC and ASEAN. This doesn't have any courts. ASEAN has a human rights body, not any court. So if we want to move with transboundary matters, so we can resort ICJ, ICC, PCA, but those are not yet started. And if we want to make responsible the governments, it is not so much likely, because these governments are not so much responsible, these countries are not so much responsible for climate change. Yes. Like Bangladesh is a vulnerable country, being victim, but this is not a country responsible for climate change. So and still state government of Bangladesh is taking enough steps for protecting the citizens. It is we have submitted NDC, updated NDC, and in 2021 we are developing NAP presently, and such steps are being taken by government. So we cannot say that government is not following the responsibilities. So we cannot sue the government so easily.
Right.
So we can consider the corporations, but corporations to be sued. Only three examples are there in Japan. There where corporations are being sued, and no other examples here. So this is still to be explored, what the avenues and who will be the defendants, who will be the plaintiffs, and more research is needed, I think.
Thank you, Momita. And maybe Bryony for the remedies.
Yeah, on remedies, something that I would like to see is a greater emphasis on participatory rights. People are going to court because they are being impacted by climate change, and they're seeing a lack of vision or a lack of implementation by their governments or the private sector. And if we think about what adaptation is, climate change is happening to Earth, whether we like it or not. No matter what we do, there will be changes. And so climate adaptation is really about learning to live with climate change and making our societies more resilient. And there aren't enough mechanisms to bring in the participation of the youth and vulnerable communities in adaptation planning. And when I see the innovations in some of the remedies that are being created within Asia, you know, I could see greater emphasis on the participatory rights. I mean, I referenced very quickly earlier a case from Papua New Guinea talking about what participatory rights would look like within an EIA. But, you know, if you have courts in South Asia that are willing, for example, to create a commission of experts, perhaps more thought and innovation is needed around who should be on that commission, who gets a seat at the table. And I think the participatory rights are there within the legal frameworks. There just needs to be greater thought given to the legal possibilities in the legal application and protecting those rights and ensuring that people have a say in their future.
Right. Thank you, Bryony. And at this point, maybe just like 2 lines to close this session, your message, your closing message to all the participants here on climate litigation. Maybe let's start with Momita, then Lisa, then Bryony, then we'll close and wrap up this session. Any parting words, Momita?
Thank you to the organizers for arranging this event and inviting us as panelists. So it's a learning opportunity for me actually, and I learned a lot from you. Thank you. Thank you.
Thank you, Momita. Happy to have you here. And Lisa?
I also want to echo my thanks to the organizers. It was really seamless and it's such a pleasure. I've learned from my co-panelists as well. I just want to say that I think it's really exciting. I think that this area of climate litigation is really exciting because you have this juxtaposition of highly vulnerable communities that really need legal innovations and judicial innovations. And now we're actually seeing the judiciary react to that need in a way that a lot of governments have not reacted. And I think particularly in the global South, where we have all of these constraints and resource constraints, I'm really proud of the courts in the global South. I think they've done a really excellent job, and it's the beginning of the journey, but they're really facing up to, I think, bravely the challenge of matching laws to the climate challenge and really looking out for the most vulnerable citizens in their country. So I think it's a really exciting time for the global South in terms of climate litigation.
Thank you, Lisa. And lastly, Bryony, fresh from back-to-back sessions. Words for me, please.
Many thanks for including me in this session. It's a pleasure, and I've really enjoyed listening to my co-panelists. I guess, climate litigation is going to be one step forward, two steps back on some days. Sometimes there will be wins, but what I do encourage people to consider is that, climate change will come into the courtroom in ways that may be unexpected in most routine of cases. And it's only when we start understanding the world around us and the connections that we can build better cases and we can ask for better remedies. The laws are there to protect rights. It's just a matter of sometimes big leaps, sometimes incrementation, but don't give up. Like Lisa, I'm hopeful and I'm really proud that the courts and judges are expressing such concern and wanting to understand what role they play in climate governance. So again, thank you to this panel. I've learned so much.
Great. Thank you. Great parting words to ponder on. And as we close this session, I'd like to thank the whole panel, Bryony, Lisa, and Monita. I'd like to thank the panel for showing us how important it is to expand judicial knowledge about climate change, legal frameworks and principles, which are all fundamental to a strong rule of law, especially here in Southeast Asia. And for all these remedies which we can use to hold governments and actors accountable for meeting their commitments and complying with legal obligations for climate change. To all our panelists, Bryony, Lisa, and Monita, and to all the participants in today's webinar, thank you so much for joining us. And we hope really to see more developments in climate change as it comes soon to a court near you. All right, and again, this has been Rocky Guzman from REL. For the next sessions, you may go back to the lobby or take a break. We have an hour break for the lunchtime, and we could proceed to the next session at 1 p.m. Thailand or 2 p.m. Philippine time. That's going to be an exciting session because it's going to be the launch of the master classes of the master classes for environmental law. So please, everyone is invited to join there. And at 4 p.m. also, we have a roundtable with judges from Thailand, Australia, Philippines, and Indonesia. So please do join if you're free later this afternoon. So again, thank you very much for joining us this morning. Hope to see you in the next session. Goodbye, everyone.
Thank you and goodbye.
Thanks all. Bye.